Good morning, everyone. Thank you for joining us today. You are setting in on Extra Help's Workforce Management webinar this morning. My name is Erin Kopek, and I'm the Marketing Director for Extra Help, a workforce management resource. And today we're going to talk a little about the key issues under the employer mandate with Gilpin Gavan, and he will be introduced momentarily. A couple things before we get started. This call will last about 1 hour. All attendees are set up in listen-only mode, so you cannot speak. We do encourage you to ask questions throughout the webinar as you see fit. We'll do our best to try to get those after the webinar is complete or kind of before we get started. So feel free to do that. Hopefully everyone picks up some tips today, and thank you for joining us. Kind of want to give a brief introduction of Brent with us today. Brent Wills is a member of the Healthcare Business Organizations and Transactions and Taxation Practice Groups at Gilpin Gavan, PC. Most recently, Brent has worked extensively with employers in planning and complying with the employer mandate and other tax and employee-related provisions of the Affordable Care Act, and with various healthcare providers and clients in regard to HIPAA compliance, including responding to numerous data breaches and government investigations. He has also recently conducted a series of educational sessions on the employer mandate for the Automobile Dealers Association of Alabama and on HIPAA compliance and enforcement for the Alabama Hospital Association, State of Alabama Medical Group Management Association, and numerous hospitals and physician offices and other organizations. I turn it over to you, Brent, to go ahead and get started.
Thank you, Erin. As Erin said, my name is Brent Wills. I'm an attorney with the law firm of Gilpin Gavan. My office is in Montgomery, Alabama. We also have an office up in Birmingham. As Erin said, we're going to talk today about the employer mandate within the Affordable Care Act. We've got a lot to cover, but I just want to mention a few points quickly before we start. First, this presentation is going to be primarily tailored to folks in the 50 to 100 employee range for reasons I think that will be evident as we go along. That's not to say that anyone who's going to be a large employer subject to this mandate won't have something to take away from this, but you folks in the 50 to 100 range or not far above that are going to be my primary focus. You should have received this morning, hopefully, in addition to my slides, 3 attachments, an attachment A, B, and C. The attachment A depicts the measurement period, stability period dynamic that we're going to talk about later on. Attachment B is sort of a flow chart that works through the penalty provisions under Section 4980H of the Internal Revenue Code that we'll get to in a moment as well. And probably most importantly, attachment C includes the Form 1094C and the Form 1095C. Those are the 2 primary IRS reporting forms you're going to be using to report to the IRS in respect to the employer mandate, as well as the instructions that go along with those 2 forms. And one of my goals today is to sort of try and connect the dots between the penalty provisions under 4980H and the reporting requirements. I think a lot of times they get talked about on separate tracks because they were on separate regulatory tracks, but to the best of my ability in the next hour, I'm going to try to help you understand how one translates to the other. So with that said, you see my title here is The New Reality, Key Issues for Employers Under the Employer Mandate. And really what we have is 10 questions, again, primarily geared to those folks in the 50 to 100 employee range that if you haven't already thought about, you probably ought to be thinking about given the point in time that we're in. So, first question, are you part of an aggregated group of employers? Now, most of you are probably aware that generally the employer mandate applies to employers with 50 or more employees, and that's correct, but I want to tweak that definition just a bit today to put a finer point on it. In fact, the employer mandate applies to employers that have 50 or more employees and employers that have fewer than 50 employees if you're part of an aggregated group of employees that collectively has 50 or more employees. And if that's the case, if you're part of an aggregated group that collectively has 50 or more employees, each of the employers within that aggregated group, even if that employer by itself has fewer than 50 employees, each of those entities is going to be, first of all, potentially subject to the 4980H, Section 4980H penalties we're going to be talking about today, and each of those entities must comply with the reporting requirements, the IRS reporting requirements that we're going to discuss in just a bit. So when do these aggregation rules come into play? And there's really two general scenarios. First of all, if you're part of a parent subsidiary type entity structure where you've got multiple employers, and in particular, if one or more of those employers has fewer than 50 employees, you need to take a look at these aggregation rules to see whether you need to combine any employees within that parent subsidiary entity structure to determine whether those entities are large employers. The other typical scenario is if you've got a commonly controlled, commonly held group of businesses, what we sort of loosely refer to as a brother-sister type entity structure. And if that brother-sister entity structure is a controlled group or an affiliated service group within the meaning of Section 414 of the Internal Revenue Code, then you're going to have to aggregate the employees within those entities to determine whether those entities are large employers. Now, exactly what constitutes a control group or an affiliated service group is sort of more detailed than we have time for today, but just a couple of quick points about control groups. If you've got a brother-sister type commonly controlled group of entities and you have 5 or fewer owners who collectively own 80% or more of the equity in 2 or more of those entities, again, you need to take a look at these aggregation rules and see whether they require you to aggregate the employees within that group. Also, in applying these aggregation rules for purposes of this control group definition, watch out for family and entity attribution rules, especially if you've got a family-owned group of businesses where you've got husbands and wives, parents, children, and grandchildren owning interests. Those interests may be deemed to be owned by other individuals in the group, and their quote-unquote constructive interest may be greater than their actual interest in their actual ownership interest in the entity. So all of a sudden, that 80% threshold for control group purposes doesn't seem so high. You see at the bottom the bullet for reporting purposes. On the Form 1094-C, there are multiple places where you're going to have to report to the IRS that you're part of an aggregated group. And in fact, in Part 4 of the 1094-C, you'll actually have to identify the other entities that are part of that aggregated group. And one implication of that is that even if these aggregation rules have no relevance for you in terms of your employee count, in other words, you've got way more than 50 employees or way more than 100 employees, and you'll see why that matters on the next slide. Even if that's the case, if you are part of a related group of entities, you need to look at these aggregation rules to make sure you report properly on the 1094-C. Okay, so those are the aggregation rules. Second question, do you qualify for any transition relief? And if you've studied the final regulations that go along with this employer mandate, you probably know that they can include a laundry list of items of transition relief. And as the term suggests, the purpose of that transition relief is to help employers transition into compliance. We're not going to talk about all those items of transition relief today, but I did pick out 4 or 5 that I think will have particular relevance for the folks on this call. And a couple of quick points before we get to those. First, as you see on your slide, transition relief only applies to the penalties, specifically to delay any 4980H penalties for some period of time if you meet the qualifications. They have nothing to do with reporting. If you don't know, all large employers will report on the same schedule. The calendar, you report on the calendar year basis, beginning with calendar year 2015. The transition rules do nothing to alter that. They only deal with penalties. Second point on your slide, there are conditions attached to each of these items of transition relief. I'm going to talk sort of generally about kind of the threshold requirements for these various items of transition relief, but even if based on what you hear me say today, you think you might qualify for one or more of these items of transition relief, I admonish you to make sure you look at the fine print because there are additional conditions you'll need to meet rather, to qualify for that relief. Now, with that said, just a few of these specific items of transition relief, and again, this is not an exhaustive list, just a handful that I thought might be appropriate for our audience today. First of all, as most of you are probably aware, if you're a large employer, if you have 50 or more employees, but you have fewer than 100 employees, and you meet some additional conditions, you may be able to delay any penalties under Section 4980H until next year, until calendar year 2016. Now, in making the determination whether you qualify for this transition relief, here again, those aggregation and attribution rules that I mentioned will apply. Also, there's a special 6-month transition rule that may help you. We're not going to get into the nuts and bolts of how you count employees for purposes of this employer mandate, but just generally speaking, you'll count your employees. Employers will determine whether they're large employers based on a calendar year. At the end of each calendar year, looking back at the calendar year just completed, determining the monthly average number of employees just completed. The average is 50 or more, then for all of the next calendar year, you would be except that this year, this first time, to determine whether you're a large employer for 2015, looking back, calendar year 2014, you don't necessarily have to use all 12 months in calendar year 2014 to determine your monthly average number of employees. You can use any period of 6 or more consecutive calendar months during 2014 to make that calculation. So all that to say, if you're somewhere around that 50 threshold for whether or not you're a large employer, or if you're somewhere close to that 100 employee level that determines whether or not you qualify for this transition relief, make sure you take this 6-month transition rule into account when you count up your employees to make sure you get the most favorable, which is to say the lowest possible employee count. Now, the next item of transition relief, letter B on your slide, even if you don't qualify for the transition relief for large employers with fewer than 100 employees, still no penalties for you in any month during 2015 unless you have more than 80 full-time employees. Now we're going to talk later about how you quantify your number of full-time employees in a particular month, but as you know, for purposes of count, or as you probably know, for purposes of your employee count for this employer mandate, we take into account not only full-time employees, but also your non-full-time employees, those quote-unquote full-time equivalent employees. So even if your total number of employees is greater than 100, unless you have more than 80 full-time employees, you won't be subject to any penalty for months during 2015. Letter C, non-calendar year health plans. If you have a health plan, your planned year begins on some date other than January the 1st, and it's been that way for a period of time, and it varies depending on circumstances, and you meet some other additional conditions, you may be able to delay any penalties under Section 4980H until the first month of your 2015 plan year. Or if you also qualify for the transition relief for large employers with fewer than 100 employees that we talked about just a moment ago, you may be able to delay penalties all the way till the first month of your 2016 plan year. Now, I've emphasized there are additional conditions on these items of transition relief, and this one in particular the transition relief for non-calendar year health plans, the conditions are lengthy and, suffice to say, not a model of clarity. So particularly given there may be several months or maybe even more than a year's worth of penalties in the balance before you rely on this transition relief for non-calendar year health plans, it's critical that you read the fine print and make sure you meet all the conditions. Item D, offer of coverage to children under 26. You'll see on the next slide that to avoid the big penalty under Section 4980HA of the Code, you'll need to offer coverage to your full-time employees and their children under 26, except if you don't currently offer coverage to the children, there is a transition item or an item of transition relief that may permit you to avoid a penalty this year only in 2015 if you don't offer the child coverage. But again, there are additional conditions on that relief you need to make sure that you comply with. Two quick reporting points at the bottom. If you look at the 1094C and the 1095C, you'll see that in both cases you'll need to report to the IRS when you qualify for transition relief, and not only that you qualify for transition relief, but which items of transition relief you qualify for in a particular month. So that can be a bit tricky as well. Question 3. Have you confirmed that you are not subject or that you won't be subject to the big penalty under Section 4980HA of the Internal Revenue Code? And this is the most feared provision in this employer mandate. And the reason it's called, well, this is the penalty, back up a step. This is the penalty that would apply if you don't offer coverage to your full-time employees, or if you don't offer coverage to a sufficient number of your full-time employees. The IRS would impose a penalty based on, and this is the key word, your total number of full-time employees. That's why it's called the big penalty. The penalty is $2,000, and that's an annualized dollar amount. It's actually $167 per month, but $2,000 annualized multiplied by your total number of full-time employees. That's in contrast to the penalties under 4980HB that we're going to talk about in a few minutes, which would be imposed on a full-time employee by full-time employee basis. Now, we have an idea what this big penalty is. How do we avoid it? And as you'll see, because of some of these various items of transition relief that we've discovered, the answer to that question is a bit different in 2015 than it is in 2016 and later years. And I referenced that attachment B earlier. If you like flowcharts or decision trees, take a look at that attachment B and it will walk you through the penalty provisions and how those apply both in 2015 and 2016. And so, starting with 2015, to avoid the big penalty in 2015, and we're talking about 2015, so remember here we're primarily talking about you folks with 100 or more employees. To avoid the big penalty in 2015, you must offer health insurance coverage to not less than 70% of your full-time employees and their children under 26, unless you qualify for that transition relief that I mentioned a moment ago for the child coverage. If you don't, you pay a penalty, again, equal to $2,000 multiplied by your total number of full-time employees, in this case, minus 80. And there's a carve-out under the statute and how you compute the penalty. In 2015, that carve-out is the first 80 full-time employees, and this correlates to the transition relief we mentioned on the prior slide, that 80 full-time employee carve-out. So if we assume that you have 100 full-time employees, you don't offer coverage to at least 70 of them in 2015, then you'd be subject to a penalty, again annualized, in the amount of $2,000 multiplied by 100 full-time employees minus 80. So 100 minus 80 is 20, multiplied by 2,000 is a $40,000 penalty for 2015. By the way, that penalty is not deductible for tax purposes. I get that question a lot. The penalties are not deductible. One last point about 2015. If you qualify for that transition relief for non-calendar year health plans that we mentioned on the prior slide, note that that 70% minimum coverage threshold, that a full-time employee carve-out for purposes of calculating the penalty, and that transition relief for the child coverage applies throughout your 2015 plan year. So even to the extent that goes over into calendar year 2016, those items of transition relief would be available to you. Okay, so that's 2015. Now we move forward into 2016, and now we've got all large employers coming on board, including those folks who qualified for the transition relief for large employers with fewer than 100 employees that we talked about earlier, and all these other items of transition relief fall away as well. So we're really back to the general rule. That means in 2016 and beyond, if you're a large employer subject to this employer mandate, to avoid the big penalty under Section 4980HA, you would need to offer health insurance coverage to not less than 95% or all but 5. We'll come back to that little parenthetical in a moment, but generally speaking, you need to offer coverage to not less than 95% of your full-time employees and their children under age 26, or you pay a penalty, again, equal to $2,000 multiplied by your total number of full-time employees, in this case, minus 30. So to continue with our example, if you have 100 full-time employees minus 30, it leaves you 70 multiplied by 2,000 is a $140,000 penalty if you don't offer coverage to at least 95% of your full-time employees and their children beginning in 2016. So you see that once those items of transition relief fell away and no other circumstances changed, that penalty went from $40,000 to $140,000 between 2015 and 2016. And by the way, that penalty calculation does not take into account any coverage that you actually offered. So for example, if you offer coverage to 50% of your full-time employees and their children, you would be obligated not only for the cost of offering that coverage, but you'd also pay a penalty of $40,000 or $140,000, depending on which year it is. The amount of the penalty doesn't change depending on what coverage you may have offered. Next point, aggregated entities must be disaggregated for penalty purposes. So we talked about you may have employers with fewer than 50 employees who, by virtue of these aggregation rules, are deemed to be large employers because the aggregated group has 50 or more employees. Once you make that determination, those entities are disaggregated. So again, even if one of those employers has fewer than 50 employees, it still must offer, depending on what year it is, 70% of their full-time employees or 95% of their full-time employees and their children health insurance coverage to avoid a penalty. But, and this point may have some relevance for a number of folks on the call today, going back to that little parenthetical, that all but 5 parenthetical for 2016, beginning in 2016, when that 95% threshold kicks in, if you have fewer than 100 full-time employees, the rules say you're only obligated to offer coverage to all but 5 of those full-time employees to avoid the big penalty. So for example, let's say you've got 50 full-time employees, you offer coverage to 45 of those 50 full-time employees, and even though 45 is only 90% of 50 and not 95%, because you offered coverage to all but 5 of your full-time employees, you would be safe from a penalty under 4980HA, the big penalty. The next point, Roman numeral 6 there, I think it's a fair question to ask if you're talking to your advisor, if you're trying to do your calculations yourself. What happens if we do nothing? Whether it be nothing ever or nothing in the near term. I had a client recently who is a small businessman. He's got his hands in a number of different entities, and because of these aggregation rules, suddenly all these small entities are going to be treated as large employers. He had not historically offered health insurance coverage, so he's scrambling around trying to slap a plan in place to avoid a penalty. And I asked him, let's take a step back for a second. If I told you that if you did nothing, your penalty for 2015 would be X, that be good news or bad news? Would you prefer to take that dollar amount X, plug it into your budget for 2015, and take some time to make sure you put in place a thought-out, meaningful option for your employees and for yourself beginning in 2016? May or may not be what he decides to do, but again, the point is that I think it's worth asking before we jump to conclusions. What happens if you do nothing? 2 bullet points at the bottom for reporting purposes. On the 1094-C, really the overarching purpose of the 1094-C is to communicate to the IRS whether you're subject to this big penalty under 4980HA. And if you look at page 2 on the 1094-C, Part 3, Column B and Column A. Column B is your full-time employee count. Each month you plug in your number of full-time employees in that month, and we'll talk more about how you make that determination later on. But then in column A, you're going to check a box to verify, hopefully, that you've offered coverage to the requisite number of your full-time employees and their children, so that 4980HA does not apply to you. Or if you haven't offered the coverage, hopefully, you'll check the box to verify that you qualify for some item of transition relief, so that an offer of coverage is not required in that month to avoid the big penalty. Down at the bottom, you'll see on the IRS form 1095-C, and I should back up a step, and I don't know if I made that clear at the beginning. The 1094-C is the form you will submit that will include your entity information, report your employer information to the IRS. You'll file that with the IRS not later than March 31st each year, beginning in 2016. The 1095-C, this is the form that you'll complete and deliver to each of your full-time employees each year, not later than January 31st, beginning with January 31st, 2016. So I apologize if I didn't make that clear from the beginning. But coming back to where we are, on the 1095-C, Part 2, line 14, you'll see there's a series of boxes for each month during 2015. This corresponds to the first set of what are called the indicator code series. And if you look at page 10 of the instructions to the 1095-C, you'll see code series 1, and you'll see a series of 9 indicator codes. You'll have to select the appropriate indicator code to fill in for each month during 2015 for your full-time employees to verify things like, was the employee employed during the month? If so, was the employee a full-time employee? Was there an offer of coverage? Who was included in the offer of coverage? If an offer of coverage was not made, do you, employer, qualify for some item of transition relief so that an offer of coverage was not required to avoid a penalty? Or was that employee in what the IRS calls a limited non-assessment period? We'll talk about what that means in a bit. That employee was in a limited non-assessment period, so again, no offer of coverage was required to avoid a penalty. Take a look at the forms in Attachment C and also the instructions for more information about that. Let's see. Question 4. Do you have exposure to the affordability penalty under Section 4980HB of the Code? So let's assume you offer health insurance coverage to the requisite number of full-time employees to avoid the big penalty under 4980HA. You still may be subject to either of 2 penalties under 4980HB, depending on the coverage that you offer. And the first penalty under 4980HB has to do with this thing called minimum value. And generally speaking, your plan provides minimum value if it's responsible for at least 60% of the cost of the plan benefits. But ultimately, minimum value is an actuarial determination. If you don't know whether your plan provides minimum value, your carrier or your broker ought to be able to verify that for you. And I'm assuming for our discussion today that anyone who's offering health insurance coverage is offering minimum value coverage. If that's not the case for you, or if you're not sure, please feel free to contact me offline, and I'd be happy to talk with you about the implications of offering coverage that does not provide minimum value. But moving past the minimum value, though, we'll focus on the affordability penalty under 4980HB, and this is how this works. First question, what do your employees pay for single coverage under your health plan? The employer mandate cares not a thing about family coverage. Doesn't matter if you offer family coverage, doesn't matter what your employees have to pay for family coverage. The test, the only test for affordability under 4980HB is what your employees pay for single coverage under your plan. And let's say for discussion purposes, you require your employees to pay $150 a month for single coverage under your plan. Move to the next, to number 2 there. How many full-time employees, if any, do you pay less than that amount? $150 divided by 0.095. This, if you're familiar at all with this affordability test, this is the 9.5% test. You may have heard it talked about that way. So we take our $150 divided by 0.095, and we get a number. We punch in we do the math, and that works out to about $1,580 per month. And the question is, again, how many full-time employees do you have who you pay less than $1,580 per month? And you see the parenthetical here on your slide that says, look to the safe harbors. If you don't know, the IRS gives you 3 safe harbors you can rely on that will tell you what your employee's income for the purposes of this affordability test. That's W-2, rate of pay, which is a calculation based on their salary or their hourly rate, or also the federal poverty line. Those are the 3 safe harbors. But in any case, how many full-time employees do you have who you pay less than $1,580, relying on either their W-2 income, this rate of pay calculation, or the federal poverty line? If the answer is none, then you don't have an affordability penalty issue. And to the extent you have full-time employees who you pay less than $1,580 per month, still no penalty for those folks unless 2 things are true. First, that employee's household income reported on their individual tax return would also have to be less than $1,580 per month. Even if that's true, still no penalty unless that employee goes out and obtains a premium tax credit to purchase health insurance on the health insurance marketplace that's set up by the ACA. And if you're in a state like Alabama, where I am, that's the federal exchange. Some of you probably are in states where you have your own state exchange, but the rule's the same. Going back to the Form 1095-C here at the bottom, line 15 and line 16. Line 15 in the 1095-C, you'll have to report that amount that your employees pay for single coverage. So in our case, $150 per month goes in the box for each month in 2015 in line 15. Then in line 16, here we have our second series of indicator codes. And if you look at code series number 2 in the instructions, begins on page 10 of the instructions, I think, and carries over into page 11, you'll see here again 9 separate indicator codes. You'll have to select the appropriate indicator code to plug in line 16 each month during the year to report to the IRS, first of all, your affordability safe harbor, whichever affordability safe harbor you're relying on, and some additional information to help the IRS verify that you passed the affordability test for that employee. So that, very quickly, is the affordability test. And now we'll move on to question 5. Have you confirmed the status of any contract workers? And the issue here is, I have clients talk to me all the time about their quote-unquote contract employees, and hopefully at least the HR folks on the phone know there's no such thing. And in the context of the employer mandate, if you've got individuals out there, we're not concerned about business entities, but individuals out there who provide services for you who you give a 1099 and treat as an independent contractor, do you have a comfort level that that is a bona fide independent contractor arrangement? Not based on whether you give them a 1099, but based on the IRS's multi-factor 21-factor test that ultimately is aimed at who is in control. I think you understand the implications here. If, for whatever, if the IRS comes in and says, okay, after applying our 21-factor test, we think that this individual you're treating as a 1099 employee is in fact, by our standards, your employee, among other things, for employer mandate purposes. First of all, probably your employee count just ticked up a bit. So if you're in that range of 50 or more employees or 100 or more employees, that could be significant. But also, if it happens that that individual provides significant services for you, namely that that individual averages 30 hours of service or more per week working for you, then besides having that employee that individual recharacterized as your employee, he or she may also be your full-time employee. So you may have to offer health insurance coverage to that employee to avoid a penalty. So, and for what it's worth, I think that for the reasons of the employer mandate and lots of other reasons, we're going to see a pretty significant crackdown by the IRS in just the next few years with respect to independent contractor and employee relationships. So I think this is definitely something to keep an eye on for employer mandate purposes. Okay, question 6. Question 6 and question 7 are kind of a deeper dive into probably the most fundamental concept with this employer mandate. That is, who is a full-time employee? And it's critical that you be able to identify your full-time employees on a month-by-month basis for a lot of reasons. But for example, obviously, as we discussed earlier, to avoid the big penalty under 4980HA, you're going to need to offer health insurance coverage to not less than 70% of your full-time employees this year and not less than 95% of your full-time employees in the future. Also, for reporting purposes, any employee or any individual who's a full-time employee in any month during the year is going to need to receive the 1095-C at the end of the year. On the 1094-C, we already talked about page 2, part 3, column B, you have your full-time employee count. You're going to need to be able to quantify your number of full-time employees each month during the year. And also for, if heaven forbid, you're subject to a penalty or you're trying to accurately assess your potential exposure to penalties under 4980H. Here again, you're going to need to be able to accurately calculate or identify and calculate your number of full-time employees in any particular month. So with that said, how do we identify our full-time employees? How do we know who they are? Well, as you're probably aware, and I probably should have mentioned this earlier, but I assume at this point everybody knows that for better or worse, for ACA purposes, full-time means 30 hours of service or more per week on average. The IRS says there are two different ways, two different methods you can use to determine which of your employees averages 30 hours of service or more per week. The first method, the default method, is this thing called the monthly measurement period method. And as you might expect, under the monthly measurement period method, you determine whether an employee is a full-time employee on a month-to-month basis. That employee averages 30 or more hours of service per week in month number 1. That employee is deemed to be a full-time employee, so that you would have to offer coverage to that employee and probably his children to avoid a penalty under 4980H in month 2. And note that that's true regardless of the employee's actual hours during month number 2. Again, that employee is deemed to be full-time in month number 2 based on hours of service in month number 1. Now again, that's the default monthly measurement period method, but in some circumstances the IRS says you may elect to use an alternative method, what's called the look-back measurement period. And as you might guess, in contrast to the monthly measurement period method, under the look-back measurement period method, you determine whether an employee is a full-time employee not based on 1 month, but on a series of months, anywhere from 3 to 12 months. You, the employer, get to choose. So if the employee averages 30 hours of service or more per week across an entire measurement period, then that employee would be deemed, here again, deemed to be full-time every month during a subsequent period of months called a stability period. And it's during that stability period you have to offer coverage to that employee to avoid a penalty under 4980H. Again, irregardless of that employee's actual number of hours during the stability period. That employee, again, is deemed to be full-time every month during the stability period based on their hours of service during the prior look-back measurement period. And if you like if you're a visual learner like I am, I point you to attachment A in your materials. You can sort of see, again, a depiction of the look-back measurement period and the stability period, how they correlate, and also the administrative period that we'll talk about in just a minute. So that's just a very rough introduction to the monthly measurement period and the look-back measurement period. How those rules apply in context depends on what sort of employee you're looking at, starting with whether you're looking at an ongoing employee. And an ongoing employee are those are the folks who have been with you for a period of time. For those ongoing employees, the IRS says you may freely elect to use a standard look-back measurement period to determine whether those ongoing employees are full-time employees. And it's worth noting that, generally speaking, a large employer who elects to use the standard look-back measurement period will have one standard look-back measurement period for all of its ongoing employees. There are some exceptions to that. For example, you can use a separate look-back measurement period for hourly versus salaried employees. If you're in a state where collective bargaining is more prevalent than Alabama, there may be some flexibility there. If you've got employees in different states, you may be able to use different look-back measurement periods for those folks, or standard look-back measurement periods. But generally speaking, one standard look-back measurement period for all your ongoing employees. And just to make it easy, let's say for example, you elect to use the maximum 12-month standard look-back measurement period, and you select a calendar year. That means that for all your ongoing employees, December 31 of each year, you would look back across that 12-month standard look-back measurement period, determine whether that ongoing employee averaged 30 or more hours of service per week during that 12-month period, and if so, that ongoing employee will be deemed to be a full-time employee all 12 months during a subsequent stability period beginning in the next calendar year. That, in a nutshell, is how the standard look-back measurement period works. Now, on your slide, you'll see an administrative period, and again, that's depicted as the yellow bars on attachment A. If you elect to use the standard look-back measurement period for your ongoing employees, the IRS says you can freely elect to use up to 90 days for your administrative period. And if you don't know, the administrative period is the period of time between your standard look-back measurement period and the related stability period, where you look back across the standard look-back measurement period, calculate your employee's number of hours, and take the steps it required to offer your full-time employees coverage beginning on the first day of that stability period. And again, in the context of the standard look-back measurement period, that may be any period up to 90 days. And that's all, again, laid out in attachment A in a timeline form that probably is easier to understand than me just talking about it. We mentioned the standard look-back measurement period is specific to ongoing employees. And to give you a finer definition of what ongoing employee means, An ongoing employee is an employee who's been employed for at least one complete standard look-back measurement period. So stick with our example. Let's say you used a calendar year for your standard look-back measurement period. An employee is hired on July 1 of year 1. So before he becomes an ongoing employee, that employee's got to not only work out all of year 1, he's got to stay employed for all of calendar year 2, right? The first complete standard look-back measurement period before he becomes an ongoing employee in year 3. Now, for all your other employees, those folks who haven't yet become ongoing employees, and for lack of a better term, we'll refer to them as new employees. For those new employees, the rules are a bit different. The IRS says that for a new employee, you may elect an initial look-back measurement period, but only for certain employees, specifically only for seasonal, variable hour, and part-time employees. If a new employee doesn't fit within one of those 3 definitions, they sort of default to a full-time new employee. And if you have a new full-time employee, the IRS says you may not elect the initial look-back measurement period to apply to that new full-time employee. You must use the monthly measurement period. So in other words, for your new full-time employees, you're going to be determining whether or not they're full-time on a month-by-month basis. Now, the IRS does give you a little reprieve here in that, generally speaking, there's no penalty for not offering coverage to a new full-time employee during the first 3 full calendar months of employment, so long as you offer coverage not later than the first day of the 4th full calendar month. That first 3 months is referred to as a limited non-assessment period. You heard me use that term earlier. We'll come back to that term as well. So that's how it works for your new full-time employees. For your non-full-time employees, of course, you may elect an initial look-back measurement period, again, anywhere from 3 to 12 months, and during that 3 to 12-month period, there's no penalty for those employees. That's another limited non-assessment period. There's no penalty for not offering coverage during that initial look-back measurement period. And by the way, let me go back a step. Comparing this initial look-back measurement period to the standard look-back measurement period, we said, generally speaking, you'll have only one standard look-back measurement period for your ongoing employees. For your new non-full-time employees, meaning seasonal, variable hour, part-time, those folks, their initial look-back measurement period will begin either on their start date, or you can elect to defer the beginning of that initial look-back measurement period to the first day of the calendar month that follows the start date. So either way, you're going to have a series of initial look-back measurement periods to track for your new employees versus just one, or generally speaking at least, for your ongoing employees. Also, the administrative period, unlike, again, the standard look-back measurement period where you can freely elect up to a 90-day administrative period. For your new employees, for your new those new employees for whom you can select the initial look-back measurement period, the IRS says you cannot defer an offer of coverage beyond the last day of the calendar month that follows the 1-year anniversary of the employee's start date. So without getting into too much detail, the practical effect of that is you're seeing many employers looking at an 11-month initial look-back measurement period versus the full 12 months, because that allows, because of this restriction, that still allow them about a month and a half to 2 months of an administrative period on the back end to make sure they can timely offer coverage to those new non-full-time employees during the stability period. Let's see. Last point on the slide, watch out for the ACA 90-day wait period restriction. This is specific to new full-time employees. If you're not aware, separate and apart from the employer mandate, the IRS includes a separate restriction that precludes you from having a wait period for your health plan that's longer than 90 days. Now, there are a number of exceptions for things like, bona fide orientation period that may extend that 90-day period, but I think you see the rub in that technically you can avoid a penalty under the employer mandate for a new full-time hire by offering coverage not later than the first day of the 4th month of employment. Obviously, that extends beyond 90 days. So if you haven't done this already, take a look at what you're planning to do to offer coverage to comply with this employer mandate versus your wait period. See if there's a problem there. You don't want to be focused too much on the employer mandate and get hit with a penalty on this 90-day restriction on wait periods. Let's see. Sticking with measurement periods for just a moment more, and this is really the $64,000 question, really with respect to this entire employer mandate, but especially with respect to reporting. We talked earlier a couple times about how you quantify your number of full-time employees each month, and you're going to have to report that Part 3, Column B on the Form 1094-C. And we've gone through this whole exercise on the prior slide to give you some concepts and terminology to help answer this question. And I'm making an assumption here that large employers will elect the standard look-back measurement period for their ongoing employees and will elect the initial look-back measurement period for their new variable hour, seasonal, and part-time employees. But if that's not what you're planning to do, then this will look a little bit different. But assuming that's the case, then when you go to calculate your full-time employee count in any particular month, and there are some minor exceptions on the margins, but generally speaking, that full-time employee count will include 3 categories of employees. First, each new full-time employee who averaged 30 hours of service per week of the preceding month, because remember we're applying the monthly measurement period here, and who is not in a limited non-assessment period. Remember, during the first 3 full calendar months of employment, that new full-time employee is in a limited non-assessment period. Category number 2, each new seasonal, variable hour, or part-time employee in a stability period who is deemed to be a full-time employee during that stability period because they averaged 30 or more hours of service per week in the prior initial look-back measurement period. The third category is any ongoing employee in a stability period who is deemed to be a full-time employee during that stability period because that ongoing employee averaged 30 hours of service or more per week during the prior related standard look-back measurement period. Now we go to on the 1095-C, we're trying to determine whether a full-time employee, or rather an employee is a full-time employee in a particular month. So you can select the appropriate indicator code, right, to plug in line 14. If the employee falls in one of those 3 categories that we just discussed, then the employee is a full-time employee in that month for purposes of the 1095-C. Now that is a whole bunch of jargon and terminology and a very compressed amount of space and time, but I think if you take this slide and track back through all the various terms, it will help sort of bring into focus how you do that calculation of your how you do that full-time employee count on the 1094-C. Okay, question number 7. We talked about the difference between your new full-time employees and your new seasonal, variable hour, part-time employees. You only can elect the initial look-back measurement period, and therefore, avoid an obligation to offer coverage for 4980H purposes with respect to those seasonal, variable hour, and part-time employees. So what are the definitions of those 3 categories? And the key here at the outset is you make this determination looking to the facts and circumstances as of the employee's start date. So if on the employee's start date, it is reasonable, number 1 here, it is reasonable to expect the employee will average less than 30 hours of service per week during that initial look-back measurement period, whether it's anywhere from 3 to 12 months, whichever you select. The employee is a part-time employee, and so you may elect to use the initial look-back measurement period for that employee. Number 2, if looking at the facts and circumstances on the start date, you cannot reasonably determine whether the employee will average more or less than 30 hours of service per week during that initial look-back measurement period, then the employee is, and I put in the parenthetical, or may be, because there's a lot of uncertainty on this particular issue. That employee, theoretically at least, meets the definition of a variable hour employee, and so theoretically, you may elect to use the initial look-back measurement period. Now, because there is a lot of uncertainty over exactly who meets the definition of a variable hour employee, the IRS has given us 3 factors to consider. This is not an exhaustive list of factors, and there's not one of any of these 3 that's controlling. But for purposes of trying to determine whether you have a variable hour employee, and specifically whether it's reasonable to determine as of the employee's start date whether the employee will average more or less than 30 hours of service per week, the IRS says look at these factors, which are, make sense. Is the employee replacing an employee who is treated as a full-time employee or a variable hour employee? Do the employees that you have that are in similar, the same or similar positions, how do you treat them? Do they typically full-time employees, or do they actually, do their hours actually vary above or below 30 hours of service per week? And the last one, what are the employee's reasonable expectations about the position? What has been communicated to the employee, whether in a job description, in an interview, however you marketed the position? Based on those factors, what does the employee reasonably expect? Is it reasonable for that employee to expect they will average 30 hours of service or more per week, or that their hours may vary above and below 30 hours per week? Finally, number 3, if the employee is hired into a position for which the customary period of employment is 6 months or less in a calendar year, and generally begins at the same time during each calendar year, and the examples they always use are a snow ski instructor or a retail worker during the holiday season. If those 2 things are true, then the employee is a seasonal employee, and so you may elect, again, to use the initial look-back measurement period for that employee. And note here, this is true even if the employee actually averages 30 or more hours of service per week while employed. So even if that's the case, if the employee meets the definition of a seasonal employee, you still may elect the look-back measurement period. And the last bullet on the slide, just by way of review, again, any new employee who meets the definition of part-time, seasonal, or variable hour, you may elect the initial look-back measurement period, and during that initial look-back measurement period, whether it's 3 to 12 months, those employees will be in a limited non-assessment period, meaning that regardless of their number of hours, there will not be a penalty prior to the end of that period. Okay. I'm going to move very fast through these last 3 slides because I know we're running up on time, and I apologize for that. And there may be questions, and if I don't get a chance to answer your questions, please feel free to contact the moderator or contact me. You should have my contact information. I'll be happy to address those questions. But back to the slides. Question 8, are there any special circumstances that apply to you? The first one you see here is the seasonal worker exception. If you're in that range of somewhere close to 50 employees or somewhere close to 100 employees for purposes of qualifying for that transition relief, and you use seasonal workers, if but for those seasonal workers, you might get under 50 employees or under 100 employees. Take a look at this seasonal worker exception. It's more technical than that, as you might imagine, and there are some additional conditions, but I wanted to put that on your radar screen for those folks who aren't aware. The next bullet, if you're a large employer for the first time, or you're treated as a large employer for the first time in 2016, meaning either that you're a new employer or in 2014 you had a monthly average number of employees that was less than 50, and now for 2015 your monthly average number is going to be more than 50. If that's the case, then the IRS gives you a grace period in 2016. So long as you offer coverage to whoever your full-time employees are, by April 1st, there won't be any penalty for January, February, March. There are conditions on that rule also. So if you're going to be treated as a large employer for the first time in 2016, again, make sure you read the fine print and you meet the conditions. Break-in service and rehire rules. If an employee has a break-in service of 13 weeks or more, meaning they have 0 hours of service for 13 weeks or more, subject to some exceptions for things like jury duty and military leave and so forth, you may treat that employee as a new employee for employer mandate purposes when they come back to work. So you apply that new employee analysis that we talked about. Same for this rule of parity. If the employee has a break-in service of 4 or more weeks, meaning 0 hours of service for 4 or more weeks, and that break is longer than the immediately preceding period of employment, you may treat that employee as a new employee when they come back. Educational and government employers, some special rules for those types of employers. For example, if you're an educational employer, your work year looks a good bit different than most employees. There are different break-in service rules for educational employees. And government employers, they're still trying to figure out, I think, what to do about the aggregation rules as it pertains to government employers, but I think that's still an open question. But the bottom line is, if you're in the education industry or you're a government employer, there are some wrinkles in the rules that apply to you, that may apply to you. For certain employees, and the examples they use in the regs are commission salespeople, home health workers, I think airline employees is another one, folks whose hours of service, or the way those methodologies calculating those hours of service don't necessarily dovetail with the employer, how the employer mandate works. There's some special guidance in there for how you deal with those types of employees. Staffing arrangements, I could talk a lot about staffing arrangements and the employer mandate, but if you use a staffing agency, they provide temp workers for you. If there's any concern over whether those employees, again from the IRS's perspective, are your employees or the staffing agency's employees, there is a mechanism in this employer mandate where the staffing agency can offer coverage to the employee, and that offer of coverage would be attributed to you, the employer, in the event that, for whatever reason, that employee the IRS treats that employee as your employee. It's obviously more technical than that, but I wanted to put that on your radar screen if you're using a staffing agency. Let's see, we talked on slide number 9, we talked about you'll have to prepare and deliver Form 1095-C to all your full-time employees each January. Line 1 and line 2, we talked about those indicator codes. Really recommend, especially if you're going to be hands-on when it comes to the reporting, that you familiarize yourself with those indicator codes as well as the instructions that go with them. I think that's a great tool to use not only for reporting purposes, but just to understand this employer mandate. Part 3 only comes up with self-insured employers. I don't know how many self-insured employers we may have on the call, but the 1095-C, if you look at it, has 3 parts, Part 1, Part 2, Part 3. All employers complete Part 1 and Part 2. Only self-insured employers complete Part 3, and in Part 3 you're going to have to report if you're a self-insured employer. You'll have to identify the folks covered under the plan, including Social Security number, date of birth, I think, and some other personal information. So besides the reporting compliance aspect, that has some other privacy and other legal implications as well. Let's see. Question 10, have you taken the appropriate internal administrative actions? If you don't know, we've talked a lot about the calendar year and calendar months, and that's what 4980H is focused on, but there is a mechanism. The rules do permit you to, if you don't use a payroll period tied to the calendar, you can reconcile your payroll periods with those calendar month, calendar year requirements. Are offers and refusals of health coverage documented? My understanding is now that most carriers, especially those who use an online open enrollment mechanism, that they are capturing offers and refusals of coverage. Not to say you can't do your own diligence and document that as well, but obviously that's a key keys to avoiding a penalty under 4980H. Does your plan discriminate in favor of highly compensated employees? If your managers, owners, or other high earners can get more and better benefits under your plan than your lower earners, that may be okay today if you're a fully insured plan. There are penalties for that already for self-insured plans, but technically, if you're a fully insured plan, you can still discriminate between classes of employees, but the Affordable Care Act statute mandated that the IRS develop rules to prohibit or at least penalize discriminating against highly compensated employees. We haven't seen those regulations yet, so the status quo continues, but that's something to be aware of. Number 4, 2018 all of a sudden is not so far away. Have you assessed your potential exposure under the Cadillac tax, which is really separate from the employer mandate, but something that should be on your radar screen. 5, are changes required to internal policies and procedures and or your health plan documents to facilitate your compliance? So for example, do you need to make a change to your health plan document to reflect ACA requirements, including, for example, whatever initial and or standard look-back measurement period you select, to make sure that your plan is consistent with what you, with your health plan is consistent with your ACA planning strategy. And the last point, perhaps some of you in other states have started receiving notices from the health insurance exchange when folks try to apply for and obtain these credits. We haven't had them yet in Alabama. I don't know that really anybody has, but the point here is that at a point in time, you're going to start receiving notices that an employee has applied for a tax credit, whether they're eligible for it or not, and that can factor into whether or not you're subject to a penalty under either 4980HA or 4980HB. You need to have a mechanism in place or process in place to process those notices when they come in, because they are appealable, and respond to them appropriately. That was a whole lot of information, particularly on those last 3 slides. And I apologize for having to rush through. I do want to point out these additional resources here, a number of IRS resources and some others that contain boatloads of additional information and detail on these on this employer mandate. You probably noticed going through the slides that there are a number of hyperlinks embedded in the slides. You will get, from me, a PDF copy of the slides afterward, and you can go through and click through those links and get additional information that way as well. I don't know if we have time for any questions. I'll defer that to Erin, but I can certainly answer them if we have some.
Let's see. Let me pull them up here, and I believe we can take care of a couple here real quick. All right, okay. So the last question was, what are payroll periods being used to identify full-time EEs? I guess, what does that mean?
Well, what it means is that the penalty provisions under 4980H are tied to the calendar year and or the calendar month. However, the rules will allow you to, if you have a payroll period that's not tied to the calendar, you can use your payroll information and, for lack of a better way to put it, attribute that information to the calendar month, if that makes sense. If they say if you use the last period that begins before the calendar month and that runs through the last payroll period that ends before the end of the calendar month, you can treat that as your for example, for tracking hours, you can treat that as the calendar month, if that makes sense.
All right. Would agriculture employees working during harvest or spring planting have any special exceptions?
Yeah, those folks, it probably depends on the specifics, but they could be either seasonal and or variable hour employees, in which case it would probably be a great benefit to the employer to elect the initial look-back measurement period. That's a very general answer, but I think you have to know more facts to get to a specific answer.
How do we?
But I think yes, there definitely is some special treatment for those folks.
Sorry about that. We'll do a couple more. How do we treat employees that worked temp to perm?
Again, I think it depends on the particulars, but it depends on. I've had this question, and there's always a gray area, but generally speaking, temps are going to remain to be treated as the employees of the staffing agency. At whatever point they, depending on the contract terms or whatever, they transition over to the full-time, rather to the client, to the employer, then that would transition. I think that's where that safe harbor that I mentioned earlier provides some protection. If there's questions about exactly when that employee is the employee of the staffing agency versus the client, I think that safe harbor can, like I mentioned, if the staffing agency provides an offer of coverage to the employee and the requirements of the safe harbor are met, that offer of coverage would be attributed to the client for purposes of 4980H. That's a long way to say that they need to take a look at the safe harbor and see if it provides them some protection.
All right, I believe we are out of time, so I'm going to go ahead and wrap up. Thank you everyone for joining us. Thank you, Brent, for providing us this valuable information. For those of you that did type out a question, we will take care of those offline after the webinar, and I will also be sending you the recorded webinar. So thank you for tuning in today, and hope you have a great day. Thank you.